About.
That should be. Like, you're not gonna convince me.
I don't
otherwise of
yeah, I
that.
don't
They do
I don't
not.
agree with the determination making your
Half an hour each.
and circumstances, I believe. Exists.
Do you believe in capital punishment?
Well, I
In
was.
regardless of the circumstances.
You know,
We've got to punish them.
when I see this come in.
Hold on.
It should be a simple answer. If
Well, but
if it's pro-life and everybody's getting informed of that, it shouldn't be a big. No, I don't. Okay, fair enough.
This circumstance, such as given the 3 seconds here, so
I got it front of it.
non-circumstantial.
Well, I really.
Even in the sense vulnerable, even if that's done nothing to did not want to experience new things in the world, but nonetheless exists.
Yeah.
Based on a set of circumstances. Rather than
Yeah.
person shaped set of DNA and will never be created.
Oh, yeah.
You need to set of DNA.
Right.
So that's.
Yeah.
Oh, wow.
Lot of things.
Yeah.
If you say it's circumstantial.
Yeah.
Be careful. It's just. You're telling me. I should. Good morning. Good morning. You.
Oh, fine, forget.
Do we have?
Yeah, that is the. I don't.
We're here.
Disagree.
I'm a little, there's somebody tangled with the semi and that never ends well.
Yeah.
I don't think.
The only thing I want to point out is that one's sterile.
Okay.
Okay, when it comes around.
What we're
Carol
doing
is
is
I'll reuse.
Okay.
kind of is. You're-
Our
you're-
founding documents espouse the right to life
Cited sheet.
implicitly.
They also, you know, at the time had slaves, so I mean, come on. That's
But
not a valid argument.
The slaves were born and then had a right
They had
to.
no rights. They had no rights.
Well, they were born, they had more rights than the unborn.
They had the same rights as a dog. They could also have been shot in the backyard any time for setting their monster. That's not.
Are you respectful?
But we still live in a
Okay, and
country
you
that's
are-
right and wrong.
But the.
Liberated.
With constitutions, we can right and wrong. That's morality.
No, because the right to life is already explicitly written, it's not.
Yeah, you know what?
You know, if we go doing something to be the right to life, then we are amending.
Okay.
Those documents.
I apologize for my delay, but I was stuck in traffic and we really we're not moving, so.
We're the only one who was late, so.
Right.
Don't be late, we get in like heated.
I know, I was like,
It's actually not heated, it's.
Can I say either one of you from, yeah, that's how you learn stuff, to be respectful.
Okay,
I would like to call the August 24th, 2023 meeting of the Ohio Elections Commission to order. It is 10:20. First order of business is the approval of the regular meeting minutes of August 10, 20.
Roll call.
Oh, I'm sorry.
We know
Sorry.
here.
I'm sorry.
That's not a problem.
Okay, I promised I was gonna be
Ms. Hagan.
on it.
Present.
Mr. Knight.
Here.
Mr. Polkie. Here. Mr. Caraway. Chair Kaufman.
Present.
All present with the exception of Ms. Tavares.
Okay, now, the first order of business is the approval of the regular meeting minutes of August 10, 2023. Do I have a motion?
So moved.
Second.
To take a vote to excuse her absence.
Well, yeah, but let's, since we already got the motion,
So I was
for
in
4 minutes, let's do that
Right.
first, and then we can do that.
All right, so we have a motion to approve the minutes, that's been duly seconded. All in favor, signify by saying aye. Post same sign. Motion carries with a vote of 6-0.
Thank you.
At this time, do we have a motion to excuse Vice Chair Tavares?
So moved.
Second.
Okay, we have a motion on the floor. This has been duly seconded. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 6-0. All right, first item on the agenda is a preliminary review.
Well, you can call them separately, we can argue on, or we can call them together, we can, since they're essentially the same person.
Okay, all right, the first is 2021G -018 Hicks versus Committee to Elect Alan Freeman et al. So, can I see we have? Brian?
I think.
No, I'm just
any
thinking-
Motion that,
Yeah, Mr. Bryan would go first because it's his motion that we're here to address, which is the motion to continue. You all have my recommendation, which is to grant the respective motions and.
I've never received this motion.
I served you.
Not that I have any recollection of.
I didn't serve, but I know he sent a copy to me.
I've never gotten, so I object to the motion being heard because I've never been served the motion.
I believe I served him. You know, if we need to continue this, so we serve, you can argue that that's fine, but I believe I did serve.
I didn't.
And if he says he didn't receive it, sometimes that happens in email. I don't know what to say.
If I had known it was even gonna be a thing, I would have been not wanting to make a trip to Columbus because. But I never was aware that there was a motion gonna be considered at all. Nor do I believe I was ever served a motion.
Do you have like on your email or anything where?
I
communication.
track that down. I don't have it with me, but that's ordinary course. We
Sure.
serve copies of everything.
Can I get a copy of whatever motion you're talking about right now?
Yeah.
Yeah. That's the question. Yeah, we should, before we get into, I think what we get into.
So I'd just like to note. I'd have to look to see if I was served, but this is from April.
Correct.
And nobody ever scheduled any motion hearing, so, nor has it ever been brought to my attention, so. I don't know that I was served this or not, but I'd have to go check more since it's so old. But also I received no notice that this motion was going to be considered or argued.
I do want to note that, Mr. Caraway has recused himself and stepped out of the meeting at this. So,
I can't. I mean, I assumed he had it. I assumed everybody knew what today would be talking about. As much as I would like to go forward and argue the motion to continue the day, if Mr. Hicks says he did not receive it, I don't think it would be just to require him to respond to a motion he didn't know he was going to argue to. Because I'm in that situation. I'm not going to make a different argument when it's somebody else's ox is being worked.
But effectively, that achieves the same purpose, so I think that's self-serving. I'd like there to be a preliminary hearing, because by saying continue, it's either ways, it's making there be a continue.
Yeah, all of a sudden, the joy of the state system, my emails, I'm not connected to the state legal system. Because I was gonna double check,
Mr. Richter.
but I can't because I'm disconnected from the state legal system for some reason.
My understanding was, and I'm not trying to prejudice Mr. Hicks's right to know what we're talking about if in fact he doesn't know. And I thought I served him, but he says he didn't receive it, and who knows? You know, we've had experiences with that before in these cases. My understanding is that today was to be an argument about the motion to continue. And I was advised by Phil Richter not to file a substantive response to the case on the merit until that motion had been considered. And if it were denied, then obviously a preliminary review would be scheduled presumably shortly. If not, there would be a wait until the appeals on the original case were resolved. The idea being that this case 2121 G18 and the case 2022 G14 are Hicks v. Freeman campaign. The case that's on appeal was 2020 G19 is still on appeal. It was also Hicks v. Freeman campaign. Every single one of them dealt with the 2020 primary. Every single one of them dealt with.
I want to object to this. He's effectively arguing his motion right
I
now.
would say that we really need to hold our comments until I believe Mr. Richter's found it.
Okay.
Thank you.
I'd also like to object the fact that clearly there's ex parte conversations that are happening with the director on what motions are going to be heard and when that I'm not even told about or a party to, which I think is inappropriate, and it's got to stop in this commission, that there's special treatment for certain lawyers that other people don't receive. All conversations with him by either one of us should include us all. So that we know what's going on and there shouldn't be, and if we are going to have motion hearings, as what happened in 2020, I think it was 2021 G019, those should be on the agenda. Previously, motion hearings were on the agenda with what motions were going to be heard. That seems to have slipped away also.
Since Mr. Hicks has raised the point, I did not, about ex parte communications, I would respond by saying that my understanding has always been that the executive director serves a function like the bailiff of a judge. You cannot ex parte a judge, but you can talk to the bailiff. And the bailiff will filter things so that the judge, in this case, the commissioners themselves, are not improperly influenced. But there is improper influence, I would suggest, if Mr. Hicks, as he has repeatedly done, communicates directly with the members of this commission themselves. As a lawyer, I can't do that without following the ethical provisions. And Mr. Hicks, notwithstanding being instructed not to do so, has continued to do so. And that prejudices people who aren't for us. If we get to the merits, we can talk about that, but I raise it now only because Mr. Hicks raised that issue, which really isn't before us, right?
Well, what I'm seeing in my emails is I got these motions from Mr. Bry, and there is not a two or.
No, I did a separate email to Mr. Hicks, is my recollection.
Oh, okay. I was gonna say, and the email to me, he is not either listed or a CC. I did broach the subject of continuing these matters at a July 20 meeting that didn't work schedule wise for one or both of you. I can't remember which. And so then I set the matter for today. So that's the contact that I've had as it relates here. So.
Madam Chair, if the communication was by email, Mr. Hicks appears to have a computer, could he search and see if he
Right.
has received it?
It was probably by email. Sometimes I do it by mail. Actually, this one was by mail, but I can verify this. And the reason I know that is because I remember talking to that secretary, make sure you mail it to him. And she might have emailed it to him, but I'll have to check when I get back to the office.
Would you be willing to look and see in your email?
No, because notwithstanding if there's going to be certain motions argued, I should be on notice that they're going to be argued. As anybody knows that's been involved in court, there can be all kind of motions get filed. And a lot of them never get argued. They just sit there because the judge never brings them forward. But so if there's going to be a motion argued, I should know. Obviously, he knew. He had communication with the executive director on the substance of the case. My communications have always been about procedure, not substance of cases. So.
Yes, I could take the last one.
Why don't I make it easier though? I'm okay with arguing these.
If he's okay with arguing this today, I'm okay with arguing this today.
But I want my objective to be noted that this commission has got to get to the point where the rules are followed the same for everybody and people are on notice of what's going to be argued. Because it sounds like effectively we're going to get to the same solution whether we argue them or not today. Is that somebody's going to want to continue this because it's kind of a catch-22. So that's why I'm saying we can argue them, and if the outcome is we continue or not continue, it sounds like if we don't argue them, we're effectively going to end up at a continuance of some sort anyway. So given that, I'm okay with arguing them, but I think we've got this commission needs to tighten up its procedure. And I'd like to argue them separately.
That's what the plan was.
Yeah, go ahead. Their parties are amenable.
And
Madam Chairman, may I argue the merits of the motion?
Which one?
Well, they're both the same.
No, I want to argue them separately.
You can argue them separately, I can present my argument as I like, and I would appreciate you not interrupting me when I argue.
They are two separate motions
Mr. Hicks.
on two different
Mr. Hicks,
cases.
Mr.
I want
Hicks,
them to be
We
argued
also-
Then
separately.
you
That's
can
my
argue-
right in due process.
You oftentimes will consolidate arguments. If you want to argue them separately, that's your choice, but essentially the argument, the essential arguments are the same across the two
That's not
cases.
correct, Phil. That's why I want to argue them separately.
I
because they're two
believe-
different-
Let's take them one at a time.
And I would appreciate it if Mr. Hicks would keep his comments to his time at the podium.
Okay, so we're gonna be respectful of one another. And we're gonna take the first case, 2021G-018, and argue it, and then we will go on to the next case, which is 2022G-014. The first case is 2021G-018, Mr. Bryant.
Thank you. As I said before, I tried to say, both cases are basically dealing, well, both cases are Hicks versus Community for Fitness. Of Alan Freeman. So you got Hicks v. Alan Freeman in 2020G019, the case is still on the field. You've got Hicks v. the Freeman campaign in 2021G018, which is the first case on the list today. And you've got Hicks versus Alan Freeman in the 2022G014 case. Every single one of them, it deals with the 2020 primary. Every single one of them deals with reported contributions and expenditures in the 2020 primary election. And even Mr. Hicks admits in what he filed this morning, I didn't read it all, but I read the first page of his 171-page submission a couple hours ago, in which he acknowledges that these are all Freeman-related cases. That's his phraseology. And he goes through, say, to understand the cases we're hearing about today, and he was dealing with both of them, and we filed a 171-page thing this morning. You need to know the background of the 2020 G019 case. I assume that's why he had this 171-page missive that I didn't read it all. I suppose you didn't either. But even he acknowledges these cases are all related. And for that reason, a continuance is proper because it avoids duplication. There's some issues, legal issues primarily, but being presented in front of the Franklin County Board of Appeals. It's all been briefed and argued. They can issue their decision where they want to. After that, there may or may not be an attempt by one side or the other to appeal to the Supreme Court, which in fairly short order, they'll say yes or no. And obviously they don't have to take jurisdiction over an appeal, but they might, depend upon how it's presented, whether they think it's appropriate. The appeals could resolve disputed issues. What's the scope of authority of this commission in cases dealing with these factual scenarios, this type of evidence, these types of facts, these types of allegations? They'll deal with issues about notice requirements. It's sort of interesting, Mr. Hicks was talking legitimately in some respect about notice requirements as a party. We have the same right of notice requirements as a party. We're arguing about that in the Court of Appeals. To the extent that there's an issue about that something gets beyond the scope of what one party thinks is appropriate, well, the Court of Appeals may help resolve that. It also presents the requirement that we present hypothetical issues. In other words, there are a number of legal issues that we would necessarily have to present before a preliminary review that may or may not still be viable issues to present once the Court of Appeals resolves the disputed matters in front of this. And generally, it's a matter of economy, judicial economy, as well as the economy of administrative bodies. You decide real disputes rather than disputes that if come. In other words, we would be in a position to say, if they rule this way on the scope of the original hearing, this is our argument. But if they rule that way, this is our argument. Not a very effective way to have a clear and understood argument about what the commission can or cannot do. And in that respect, the communications that the commission has made through its counsel on the matters on appeal, to some of them, it takes a different position about the scope of its authority than Mr. Hicks has made in some of his filings in this case and in the related cases. Presumably, even from Mr. Hicks' point of view, if the Court of Appeals goes his way, he'll CCI was right all along, and if they go in the other way, he's not going to do that. In terms of that. Yeah. And lastly, Phil Richter has recommended granted this motion, both of them, that we're arguing over 18 right now. For all these reasons, this is basically the same case with some additional facts, some additional permutations. I'm sure Mr. Hicks is going to stand up and say, no, it's way different. But the reality is, we're arguing once more about the report of the 2020 primary election campaign finance stuff. And frankly, Mr. Freeman can't know what he needs to fix or how he needs to fix this. Maybe even after the Court of Appeals and Supreme Court, if they get that far, he said, but certainly beforehand, because right now he's in a state of limbo about what do I do and how do I do it? Mr. Hicks thinks it's clear, but he also probably thinks, because he said so, that the Court of Appeals should reject our appeal. So, you know, they might not. And if they do, one thing happens. If they don't, something else happens. In either case, it changes dramatically the lay of the land in terms of evaluating the second and third Hicks v. Freeman complaints that Mr. Hicks has filed. And for all these reasons, I recommend that Phil Richter's recommendation to continue this case and the other one be granted.
Thank you.
I'm Chair, question, General, is the camcorder that is set up across the room on?
Yes.
We have to allow that. I don't really particularly appreciate that it's staring right at me, Miss Hagan.
Actually, you do need to allow that. That's the Ohio Open Meetings Act.
We have the thing on
It
camera.
doesn't matter.
We have generally allowed persons to video commission meetings over the history of the commission. And I think it's policy wise, I think it's a good decision to make. I appreciate your concerns. But it is an
Can I
open meeting.
request it not be staring right at my face and have a more broader view of the room?
I assure you, it's only seeing the whole room this way. But I also want to be clear, because Mr. Ricker is not clear, it is absolutely a requirement of the Open Meetings Act that you allow citizens to video or audio record any meeting subject to the Open Meetings Act. The only thing you can do if you want to do it in the future is you could designate a specific area for camera equipment to be put in. You can also, for example, prohibit camera equipment that was overly loud or disruptive to the meeting or something like that. But you don't have an option whether to let somebody do it or not, or to say, we're already recording it, so you can't record it.
Fair
You
enough.
can set up, and I've been in places where they might if they get really serious about it, they'll mark on the floor, this is where the cameras can go. So that there's no question, but I assure you, it's not aimed at you.
It looks like it is.
No, it's
Like,
picking up the whole,
right
it's
at-
as wide as it can go. It's as wide as it can go.
In the future, I would prefer that we designate an area that, I don't know, feels less intrusive.
Yes.
But I appreciate the comments, I do.
If I may just say, he's not a lawyer, but he's right. I mean, I don't do that because I think it will irritate you, but he's right that there is a right.
Can I proceed with mine?
Mr. Hicks needs sworn in.
Raise your right hand. Do you swear from to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you.
So my first hint that there was going to be any attempt at something happening odd here was that the agenda that is not given to the public, but that is given to you, that tells you how you're supposed to vote on matters before you, which I think the public would be shocked to realize you get an agenda that tells you how you're supposed to vote. Said on it, recommendation, grant the respondent's request, it doesn't even say motions, in the respective cases to continue the matters pending the resolution, the resolution of the appeal, the previous case involving Alan Freeman. I just want to point out that I got a copy of this agenda that you got from Mr. Richter when I asked him. He got one because when Mr. Richter walked in the room, he gave him a copy of your version of the agenda. This is where I think you guys need to clean stuff up here before this commission. As it relates to these motions that I didn't know were going to be argued today, I want to just remind everybody, the executive director controls the scheduling. The executive director controls the scheduling. He put on the schedule preliminary reviews for these matters for this hearing. If he had any question, he could have just not put it on the agenda. He controls what's on the agenda. So I find putting it on the agenda when I have to drive, I know a lot of you had trouble getting here today because of the rain. But remember, Chairman Kreitz probably four times directed Mr. Richter to put in place the ability for people who are not on the commission to be able to testify remotely. So that they didn't always have to travel, because back during COVID, you had much more participation. So I feel like I've been duped into coming here to, under false pretenses, without being informed that there was a motion that I recall any information on, or that that was what was going to be argued here, versus that we were actually going to have preliminary hearings on these matters. So he controls the scheduling. Also, I'm not sure, do we have the right mix of Republican, Democrats, and Independents right now? Because I don't see Peter Stoutberg here, but Mr. Caraway's recused himself.
2, 1, and 2.
Okay. So, okay, as it relates to the case, I'm only going to argue the first one, which is 2021 G018, because I want to have these. So just for background on why I think there should be a preliminary hearing on this matter, is the things that Mr. Bry has not mentioned. First off, what I sent to him and to Phil Richter, the 171-page filing, was records of the commission. And what was the main part of that? Okay, on September 23rd, 2021, there was a motion hearing in the prior Freeman case about whether mail and mail drops and things like that, mail post political mailers, could be considered as part of that case or needed to be a separate case. In that September 23rd motion hearing, he argued it needed to be a separate case. He argued that it needed to be a separate case, that the only thing that could be considered in the prior case was the media expenses, which were a lot of the So back on September 23rd, 2021, there was a hearing. It's probably about 60, 70 pages of transcript on this matter. It ended up, the funny part is, his motion then was that the case could not include stuff other than the media stuff. Ultimately, if you go read that, and that's what I sent to Phil Richter, I'd encourage you guys to go back and read those minutes. Not those minutes, that transcript, is that what happened was it tied, the motion failed on a tie vote 3-3. But the determinative difference was basically 0. Some of you were here because it was, if it under the normal, what was being said was the rules, I had to stick to only the media expenditures. And so kind of if it passed or failed, it didn't matter, but it failed on a 3-3 tie. So what happened was this, well, part of that discussion, if you go read that transcript, was also that I should, if I tried to amend the complaint to include print and mail, that would cause a reset of everything and we'd have to start everything from scratch. And that one of the alternative proposals to me, if you go read that transcript, was to file another complaint. And that complaint could, at the direction of the executive director per OAC 3517107, could then be consolidated. So that then it would become one case. Like the Stewart case, we'll have a Stewart case where you guys consolidated 2 things, got consolidated. I filed a second complaint on October 12th, 2021, that was specific to print and mail activities of the Freeman campaign. Remembering, he's the one that argued that that's the way I had to do it. The executive director never held a preliminary hearing on that case, which is the one before us right now. He never had a hearing and therefore was never consolidated. So it's kind of like saying you robbed the Nordstrom here and you robbed the Nordstrom here. Well, we have to have that be one case. No, they argued that it should be a separate case. So I think, and if you go back and look at the history, because I went through and looked at all the dates of what things happened at different points in time, is that the print and mail part of the Freeman campaign is a separate and distinct set of activities. Those of you here remember that basically the activities that were media was about $180,000 of unreported in-kind contributions. There was about another $100,000 to $120,000 that was unaccounted for. because there were some invoices that came out that had higher numbers during discovery. And that's, I think, the print part, the print and mailing part. So my view is that that case should be, that we should have a preliminary hearing on it versus continue it. And I think then it should be, held over for a full hearing. Okay, and then once the facts are determined, the biggest thing that would come into play for the commission is how does the prior fine relate to a finding of violation in that case? Because then you're going to get into the issues of, well, what happens if they've already been fined for having faulty statements? And now we found another issue that involves the same statements. Do they get fined again on those same statements or not? One other factor that comes into play on this case in particular, more than the other one, is this whole notion of that's going to come up and needs to get addressed by this commission of what happens if somebody terminates their committee. And I just want to point out that I have repeatedly requested that there be an advisory opinion of the Ohio Election Commission on what's the impact on jurisdiction of the Ohio Election Commission if somebody terminates their committee. Okay, I've eventually put it in an actual advisory opinion request consistent with OAC Rule 35-17-102. I hear nothing about it. I don't have the talk line with Director Richter. So that's another important thing on this case is the what's happened. Now, the good news is that Alan Freeman has reestablished his committee that he closed down. By the way, he closed down his committee in between when the commission had its public deliberation on what its finding was going to be in the prior case, and then voted on what Mr. Richter had been instructed to draft. That's when Alan Freeman, in the days intervening, he shut down his committee, and then he tried to have a motion saying that the OEC couldn't find against him because they had no jurisdiction because they shut down the committee. So that's what happened within that time frame. So on this case, on this particular case, it is from, I have to go back and look, but 2021. I have to go back and look at when was it actually filed. It's now 2023. In this, it was scheduled for preliminary hearing today. I believe that it should be held over for a full hearing, and then we could pause on doing the full hearing until these other matters are resolved. But let's get the preliminary hearing out of the way so that we can at least have this moving forward. And I haven't made a dangerous trip in the rain from Cincinnati to Columbus. So thank you.
If I may respond to a couple of points Mr. Hicks made in his presentation. First of all, he made a slur against Phil Richter. He didn't walk and hand me the agenda. I walked up to him, asked him about the agenda, just like Mr. Hicks did later, and he gave it to me as he would to anybody who comes up and asks. Secondly, Mr. Hicks spends a great deal of time talking about hearings and proceedings and evidence in the case that is on appeal. He said, let's take a look at this transcript of September 23, 2021. And there we go. We had moved, Mr. Alan Freeman had moved, that the hearing be limited to the matters that were pled in the pleadings. And that failed on a 3-3 vote. There was a suggestion by at least one of the commissioners that Mr. Hicks either amend his complaint or file a new complaint and seek to have it consolidated with the original one. Now, he did file another one after the hearings in the case had already happened or begun to happen, but he made no motion to consolidate. And the argument that I made at the time is, you need to give the respondent an opportunity to have another preliminary review, another opportunity to move to dismiss new charges that aren't in there. Now, Mr. Hicks says it doesn't matter because you were limited to what was pled anyways, but that's not what the decision in the first case did. The decision in the first case relied upon statutes, subsections of statutes that were never cited, and facts that were never alleged to be violations.
I object to this. This is hearsay on that case, that he's making representations of what your decision was.
I would ask that Mr. Hicks not interrupt me while I'm speaking.
Well, I object.
I would ask that Mr. Hicks not interrupt.
You're not in a position, they can read their own decision from the past.
that I'm talking about the decisions you have made from the past, and I'm talking to the commission. I'm not talking to Mr. Hicks. And I showed him the courtesy of not interrupting, except to affirm a procedural point.
But I object to you telling the commission that they
And I-
did certain things that they didn't do.
Okay, that's
Madam Commi-
duly noted.
Madam Chairman, I personally object to many of the false statements that Mr. Hicks has made. I did not interrupt him to correct them at the time. I'm doing that now. Or at least some of them. And one of the statements he made, if I recall correctly, you were all here just a few minutes ago, was that the commission was limited to what he pled in his complaint. Well, even though our motion to so limited failed in a 3-3 tie. So that's not how motions work. My motion failed, and it is not what the commission actually did. And in fact, this commission, through its counsel, does not deny in the appeal of the original case that it went beyond the facts alleged to be violation in this.
I object. He's
And
making
it
statements
did
about
not-
this commission that are not in evidence here.
I asked Madam Chairman to please instruct Mr. Hicks to keep quiet while I'm speaking.
I think I
rather
can
than try to make it
object.
more difficult for me to speak.
Duly noted. Your objection is noted.
As I was saying before I was so rudely interrupted, this commission has argued through its counsel in the Court of Appeals that it does not deny, it never denied, this commission has never denied in the appeals that it found violations that weren't in the pleadings that Mr. Hicks had found. It never denied that it found violations of at least subsections of statutes that were never cited in the pleadings. What it alleges in the appeal is that it has the right to go beyond and find violations of facts and of statutes that were never played.
What does this have to do? I object to this.
And what this has to do with the motion to continue is that this is a disputed fact. You can hear Mr. Hicks arguing he doesn't want you to hear about it. He doesn't want you to know that the Court of Appeals and you have done these things. I apologize. I should refer to that.
Yes, please.
But nonetheless,
Thank you.
the three case, he also said, well, since he filed a complaint, I think in October, and I'm not sure, I'll have to check the dates of when the original evidentiary hearings, but there are other motions here and so forth going on. But he never filed a motion to consolidate the new complaint with the old one. You know, he just apparently thinks that this ought to automatically happen. He never asked for this. He also never sought to amend. He could have filed a motion for leave to amend his complaint. It would, in my view, have required an additional preliminary review. If you have any facts and statutes, we should have an opportunity to defend against them, but he never sought to do that. And he said, what happens? He's telling this commission there's a big issue in front of you and why you ought to hear these new cases. Because what happens if somebody terminates their committee? That's an issue that's on appeal right now. You know, because one of the arguments we've made, and the commission has disagreed with it through its counsel, is that you can't have a fine against a committee that doesn't exist anymore. And we have, that's been fully briefed, it's been argued. That is a case, probably the reason, I don't know what the reason is, but I suspect the reason for this commission not to issue an advisory opinion on something that the Court of Appeals already has in front of it in a live case involving this commission is because whatever this commission says is probably going to be trumped if the Court of Appeals addresses the same issue that's been presented to it. One more reason why we ought to continue this case and the other until those appeals are resolved. And lastly, he makes an assertion that the same committee has been reestablished. That's simple. Well, he may not know the difference because it's not a lawyer, but in fact, it's not the same committee.
I object to being,
I was trying to be courteous, not pejorative.
Okay.
You know, but you know, the reality is that that's not the case. What has happened was Mr. Freeman had a state committee, which has the limitations that committees for statewide offices and committees for state legislature have. It was zeroed out. There was not a transfer of fund or assets. It went out of existence. And sometimes later, because everything's been pending for a while, he created a new committee that starts from ground zero that for his township trustee race, which is not a state committee. It doesn't have the same restrictions. It's not a state campaign committee. It's a local campaign committee that's filed not with the Secretary of State, but with, I believe, Claremont County, if memory serves. In other words, there's a lot of stuff here that gets complicated, it gets confusing, it gets voluminous, witness 171 page filing this morning. But if these things are continued to let the Court of Appeals and possibly, but not certainly, the Ohio Supreme Court sort out the original case, this commission will be in a much better position to narrow its focus and decide whether there is or is not merit to the new case and the new cases Mr. Hicks has brought.
Can I respond quickly? I like, so just quickly. First off, Mr. Freeman's new committee set up, he checked off both new and update on the form. And it's then get marked as he was just changing the treasurer information. So this could be later, but when he says he set up a new one from scratch. What I wanted to do real quick, just to respond to him and then be done, is I'm going to actually, in the 171 page filing was mostly me sending a copy of the transcript of a prior hearing, telling Mr. Richter that I might quote from this transcript of your prior hearing. So Ms. Cunningham, former commissioner, says, it's on page 65 if someone's to look it up. If we grant the motion, this is his motion to limit, he was trying to limit that we couldn't deal with print media stuff as part of the prior case. It had to be separate, okay? If we grant that motion, you're limited, she's talking to me, you're limited to the items specified in the complaint and 6 invoices. Mr. Hicks, okay, I think you should deny that motion. Ms. Cunningham, okay, if we deny the motion, Commissioner Norman, who was also another attorney, is saying you will be limited to what is in the complaint. Mr. Hicks, so you are just telling me us the same thing, deny, and then I get Ms. Cunningham, that's the law, that's what he thinks the law says. So that motion back then, I would encourage you, I sent him the transcript, to go read the transcript of the hearing about this, of the motion hearing about that matter back then, because I was told that no matter how that motion came out, I was limited, and my options were to do a amended, which would cause a complete restart of the whole process, or file another complaint. So I filed another complaint, and then he acts like I was not diligent after I did all that, because I didn't then do a motion. Well, I want to remind everybody that that's not my job. Per OAC 35171-07, quote, B, quote, staff attorney to the commission may, in the sole discretion of the staff attorney, not the commission, in the sole discretion of the staff attorney, consolidate cases involving substantially similar parties and issues. That wasn't a matter to be heard before the commission, because your rules say that's his decision to do that. The staff attorney solely makes that decision. So again, on this matter, on this first case, I think we should, on the first one, I want to argue the second one separately because it's a very different case. But on the first one, I want to say after all this discussion, I think it would probably be best, not that I agree with it, to just continue the matter on this first case. Thank you.
So moved.
Okay.
Great, we have a motion on the floor that's been duly seconded. All in favor, please.
I think I have some question. The executive, it's for the executive director. I guess I would like to understand the general viewpoint was that we should wait until the court process ends. Why did it come up on the calendar at all to require this whole continuance thing?
Mr. Hicks, shoot, I can't remember now, all of a sudden,
Mandamus.
a mandamus action against the commission to move certain matters forward. And these are 2 of them, and so I'm moving them forward based on that, so that we can then act on these.
Got it. But because the mandamus had moved it forward. And then you brought up that point. Okay. I'm done now. Thank you.
Okay. Yep, and in anticipation, same for the 17th.
Got it.
Madam Chair, since I had motioned the continuance, is there also any information on when those appeals are being heard? As of yet, okay, so we can't set the for
Not that I'm aware, I have not heard anything.
The Court of Appeals case has been fully briefed, it has been argued, and is waiting for decision.
Could we assign this to be heard no later than 2 meetings post that hearing or something along those lines without setting a date certain? So that it's just moving forward appropriately?
Mr. Bright.
I would say go ahead, because I think I know what you're gonna say. Go ahead.
If the Court of Appeals decides, it's possible that one side or the other will seek review by the Ohio Supreme Court. So at least from movement's point of view, it might be preferable to do a couple of weeks after the appeals are fully resolved. For a couple of meetings.
I mean, I would phrase it in simple terms. I'm sure if the decision comes against Mr. Bryce, I could be wrong, but if the decision comes against Mr. Bryce, client, he would appeal. And if the decision is against the commission's interest, I'm sure I would suggest that the Attorney General's office appeal on our behalf. So therefore, you're down the line then to Supreme Court decision. But then after that, that presumably is the end of it, is this is an Ohio issue, and so therefore that decision would presumably be final, then we can presumably be prepared to go forward, and I would certainly go as quickly as possible, yes.
Then I would say I'm fine with my original motion.
We have a motion on the floor that has been duly seconded. All in favor, signify by saying aye.
Aye.
Post same sign. Motion carries with the vote of 5-0. So that case is continued. The next case is 2022 G-014. Mr. Wright.
I pretty much presented the argument. The only two things that I would have discussed are Mr. Hicks has cited an updated treasurer. My understanding is that Mr. Freeman originally designated himself as the treasurer of his new township trustee committee and later updated it to name someone else. And I suspect that he may be looking at the second designation treasurer of the first. And secondly, again, I don't think it's relevant, but the comments that a couple of commissioners made at the hearing, they were on the losing side of the 3-3 vote. And obviously what the commission did in the original case is a matter of record, not that you need to sort all that stuff out here.
Thank you.
Okay, just to clean up some stuff, he said that the first hearing in the prior case was on October 7th. It became clear to me in that hearing that I was not going to be allowed to reference the print and mail materials. And as such, that's when I filed on October 12th, another complaint because of the actual, and the people that were on the losing side of that were people that were saying that it didn't matter which way the motion was resolved. So obviously they were going to vote on the losing side because they didn't care. Okay, on this particular case, I would also want to clarify that what he said about filings with the Claremont County for this treasurer, that's not true. I have all the forms that Mr. Freeman has ever filed as designation of treasurer forms. And the last one prior to January 11th, 2023 was on, well, November 26, 2019. So that was prior to his running for state rep. So there's been no intervening changing of treasurers. I just want to clean up factually inaccurate information. On this particular case, it is not the same as the other ones. And let me explain why it's different. This case doesn't involve the web media expenses printed. It involves specifically the treasurer, Susan Jones, filing an annual campaign finance report, which she did on December 13th, just by way of timeline. The commission on a prior matter, the commission had its public deliberations on December 7th. It was going to meet to approve what they'd instructed Mr. Richter to draft on the 16th. On the 13th, the treasurer of the Freeman campaign filed a annual financial report, which, by the way, those of you that know when these filings are due, that's very early. They filed an annual report before the year was over, and included with that a termination. And then he argued in a motion that because the committee was terminated, there was no jurisdiction of the Ohio Election Commission, and that therefore you could not find against them on the 16th, which by the way is it's not, in my view, good. Okay, so that's those events. This case, the case that we're talking about right now, 2022 G014, is specifically about the treasurer filing a annual report or whatever it was, an annual report when they knowingly that there had been things that were unreported and doing nothing on the report to report anything or to correct it or to wait for the determination of the commission to file a correct annual report. Let me say, and I'm sure Mr. Bry will object, it was effectively a stunt to file that annual report with a termination check on it to get which by the way, the gentleman who then terminated the committee was Brian Katz. Okay, so terminated the committee, and then he came in here and argued that they couldn't have a finding against the committee because it had been terminated. Unfortunately, right, wrong, or indifferent, at the time of the hearing on December 16th, you can go read that transcript. The committee for Alan Freeman still showed as active on the Secretary of State's site. If you go look at it now, it'll say it was terminated on December 13th, but at that point in time, there was no filing reflected on that site. Mr. Bright, I did have a motion that he filed on December 15th. So this case is not the same as the other one. This case has to do specifically with the treasurer, Susan Jones, and who was not a named party in the prior one, according to Mr. Bry. I think she was, but according to his arguments, she wasn't. So filing that annual report in termination while knowing that there was a pending finding that there were unreported expenses. And that's what this case is about. It's not about whether it's media expenses. It's just about the fact that an annual report, remember, there's different reports, annual reports, semi-annual. And if you guys haven't studied it, just for quick background, if you look at those code sections, the differences between like an A and B section and C, it's not that it's different matters. It's like A relates to the semi-annual report, B relates to the pre. So there's different code section in the same statute. There's A, B, C, D, and E, which points to whether it's pre-primary, post-primary, semi-annual, or annual. And one of their arguments is that if the commission finds during a hearing that, well, this expense was a problem, but it should have been on the post-primary versus pre-primary, then that would mean the whole case was void because they had not been informed that they were being held to account for a post-primary versus a pre-primary report. And that's something that should be part of, an advisory opinion as well, in my view. But in this case, I just want to point out that it's a very different matter because it has only to do with the filing of that annual report by the treasurer while knowing that there was an imminent ruling. By the way, the treasurer had sat through all of the hearings in that prior matter. So this one, I think, should have preliminary review and not be continued because it's substantially different and it wouldn't be impacted by the prior case, in my view.
A couple things, primarily related to our motion to continue, which is the motion on the floor. The motion to continue also should be granted because the whole notion about the termination of the committee is a matter that's before the Court of Appeals right now. It's been briefed by both sides. It's been argued whether that termination was effective. And Mr. Hicks has made the argument that the whole legal ramifications of the motion to continue, of the termination, or rather the termination of the committee, is something that is involved with this third case or the second case that's on the agenda today, but it's also something that's in front of the Court of Appeals today, as we said, and it's disputed. He says, well, we must be wrong on the merits because the website wasn't updated to reflect the termination of the committee as of December 13, 2021 until sometime later. I got to tell you, probably find me listed as a lawyer with firms I haven't been at for years. Websites are not always updated instantaneously. Even the website of the Ohio Elections Commission is pretty good, but it's not instantaneous when it updates things. He also, this isn't really relevant to the motion, but it is as a point of privilege. He makes several accusations of being stunned, of being dishonest, and said and everything. The reality is the commission had not voted to impose a fine orally until the 15th, which was after
16th.
I believe it's the 15th. Well, I relied upon what you said in here. And here you said that, oh, you're right, it is 16th. He's correct, I'm incorrect. It's the 16th of December when the commission met and made the vote to impose, whatever penalty imposed, which is 3 days after the termination by our count. Obviously, the commission wasn't persuaded by that and went forward and did whatever it did. Having said that, when the committee was terminated, there was no vote to impose a fine. There was a pending action, but there was no liability. And I spoke with Brian Katz and said, is this something, can we terminate the committee? And he said, yeah, you can, which is why we did, because it run out of money. And there was no particular reason to keep a committee in existence for somebody who's not running for statewide office again. And that didn't have any money. And there was there were certain advantages to doing it. You can't get blood from a turnip. And the best way to show that you're dealing with a turnip is to dissolve it, which is what we do. But the main thing is, he's saying this is different because this deals with a bunch of issues relating to the termination of the committee. The Franklin County Court of Appeals is also dealing with the issues related to termination of the committee. This is one more reason, in addition to all the other ones we've gone through ad nauseum, that this matter, like the other one, should be continued until the appeals are resolved.
I have a 10-second comment behind me. So I just want to point out, I have nothing else to say other than, again, he said Brian Katz was the person that told him they could do this stunt. And again, so Mr. Katz's name comes up again, is having these conversations on the side with other people. Thank you. And since he's watching his wife, I wanted to go.
Questions on Mr. Breyer, Mr. Hicks?
So I do, I guess, probably Mr. Hicks. So this case 19 obviously is against Ms. Jones, correct? Or is it also, does this also have culpability for Mr. Freeman?
I think I have both, frankly, because it's the committee also, and I think you're mixing the numbers up. So the one that's about the filing is 2022 G014.
Correct.
Yeah, you said 19. So.
I'm sorry. I'm looking at your evidence probable
Yeah.
cause here we had during the case, but okay. Was not,
But the actor
I
in
got
those events was specifically
Just
Susan
after,
Jones,
that's my.
the treasurer, not Alan Freeman.
So you're suggesting that this would have culpability for Mr. Freeman?
I'm suggesting that the actions were on the part of Susan Jones,
I get
and that ultimately the commission would determine what was the violation and who was culpable for it.
Okay.
Any questions from commissioners?
I guess I have one for Phil. So, Mr. Rick, so if on this case on 14, if we grant a continuance, does this in any way put Mr. Hicks' case, I guess, in jeopardy with respect to staying active and being timely?
I believe because the request is coming from the respondent, whose, let's say, rights are at issue here. And that's the one who's requesting that the matter be continued to a later date for their benefit. I would answer that no.
Will you clarify that? I'm sorry. So it would not put Mr. Hicks' case in jeopardy?
Correct.
Okay. Just want to make sure.
Yeah, I'm asking if it continue, you got it.
Because it would be hard for Mr. Bride to then subsequently come in and say, you waited too long. When we're waiting so long based on his request for us to wait so long.
Right, but I was trying to watch that with the comments from the transcript saying that his case would be limited on appeal. That's, am I confusing this?
If I may address it, Mr. Hicks read from the transcript. I don't have it with me, but I was there and I skimmed through it last night, or this morning. I didn't have it last night. The transcript were comments of two of the commissioners who voted to grant my motion to limit it. The motion was not successful. It failed on a 3-3 vote, which is a failure. And the evidence was not limited, and the decision was not limited. And so whatever might have been, that's not what happened. And that is, as I said before, a matter that is in dispute and argued in the ongoing litigation on the original matter. There's a lot of stuff in the original matter, and this case or the cases can get fairly confusing. I'm not suggesting that waiting will get rid of all the confusion, but I think it will get rid of some.
Thank you.
I just want to correct the record. So of the two commissioners whose names were mentioned, Ms. Cunningham voted no on the motion
Okay.
and Mr. Norman voted yes. So the two people who were, that's because they were two of the people arguing that it didn't make a difference. And actually then one of them voted yes and one of them voted no, which is on page 77 of that transcript.
I refer to his recollection. Obviously, he's read through it and I haven't. I thought they both voted the same way, but in any event, that's not what happened. And Mrs. Cunningham said, Mr. Norman is telling you this is how it works. May not have been reviewed. I don't know.
So, Mr. Ryan, your opinion, by us granting a continuance, does that limit Mr. Hicks' case in any way?
Well, if we're getting to the continuance won't limit this case. I think some other things will limit this case, but we haven't got to the merits of a preliminary review yet. So yes, I mean, if we.
I'm just talking about the continuance.
No,
don't want you to
I
get-
think Phil's right. If we ask for a continuance and you grant our continuance, you can't have us come back and say, well, you have to dismiss it now because the motion that we made to continue was granted. In other words,
Okay, that's
I
what I
can't do that, and I think that such an argument would be unsuccessful.
I feel differently because that's why I opposed to continuing these cases. Because when these things stretch out forever, and I don't want to sound morose, but probably a lot of people in this room know that the husband of Gene Schmidt, the treasurer, Peter Schmidt, who was a witness in that other case, passed away. So if cases take forever and you actually get to the point where witnesses are literally not available, then that affects the ability of me to put forward a case. So I think there's a balancing act that takes place. I think it's correct is that he could not come back and argue that he, was past the statute of limitations when he's the one who requested. But I think there's an interest in there being speedy justice. And when we keep stretching things out for years, literally, you do run the risk. You have witnesses who physically can never testify again.
I've been doing litigation for some time, and every court has a duty to administer justice with deliberate speed. But they define it how they define it, and there's not a lot we can do about that. I don't think if the legal system, the judicial system says this is fast enough, that we really much of a position say they're wrong.
Any other questions? Questions for Leitner, Sloan, or Mr. Richter? Hearing none, do we have a motion? We all know what Mr. Richter's recommendation was.
I'll move the motion to continue.
Second.
We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Both same sign. Motion carries with a vote of 5-0. That motion is, in that case, is continued as well. Thank you. Thank you, gentlemen. Okay, so the next,
I know, I thought it was one of
Next.
yours, but I also thought you got.
cases on the agenda are the group recommendations. The first one, we're actually gonna take some of those out of order because we have folks who've been waiting.
Yeah, give it.
Oh, yes, please, thank you.
We can do the no violation, I can certainly not you with the check. And keep it.
Okay.
Well, it's related to the subsequent ones.
Okay.
Well, if you with the no violation, you can take care of it, but just get them out of the way,
Thank you.
because those are.
It's that happened, that's on me.
Okay. That ain't a long time ago. So.
Yeah, it was.
You always have to have, you have to have a qualifier.
Okay, we are gonna go ahead and take the no violation group. Those cases are 2023R-271 and 2023R-272.
Madam Chair, members of the commission, after getting the responses in on both of these matters, they provided, information that reflected that the reports were timely filed. One, the due date was December 16th. And as I indicated in the response, reflects a timestamp of December 13th. And then the other one, again, reflects a January 24th priority mailing with expected delivery of July 27th prior to the January 31 deadline. And so therefore they were timely based on the materials presented by the respondents. So my recommendation is to find a violation.
Any questions from commissioners? Hearing none, do we have a motion?
So moved.
Second. We have a motion on the floor. It's been duly seconded. All in favor signify by saying aye.
Aye.
Pose same sign. Motion carries with a vote of 6-0. The next case we will take,
Yeah, I mean, do 289.
okay, out of order, it's 2023R-289. And I believe we have someone here for that case.
Correct. Madam Chair, members of the commission. Find my eyes going here. This is a referral from the Claremont County Board of Elections against the Beckman for Judge Committee. Ms. Beckman is the candidate. Julia Carney is the treasurer. A response was submitted wherein it said the designation treasurer was completed and signed by the date listed. The committee, they expected to open the committee account that day. Or no, they expected to get the report file, the DOT file that day, and they opened an account and made a deposit, but the DOT was not actually filed with the Board of Elections until the next day, so it was only one day late. My recommendation to the commission is to find a violation, but for good cause and not impose a fine, or refer the matter for the prosecution. Judge Beckman is here. If she wants to make an additional statement, she can be sworn and address the commission.
You swear from tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Madam Chair, good morning. Director Richter and members of the commission, good morning. I very much appreciate the opportunity to come in here and address you today. My name is Anita Beckman. I am a judge at the Claremont County Municipal Court. I was appointed by Governor DeWine last July and stepped on the bench August 1st last year. I am required to run for the unexpired term ending in December of 2027, and I'm on the ballot this November. My committee treasurer is Julia Carney. The complaint alleges that my campaign committee had activity before the designation of treasurer was filed, and that's absolutely true. I made a mistake. I think actually the designation was filed not one day late, but maybe 11 days late, based upon what I saw in the record. It's important for me to explain a couple of things so that you and the citizens of Ohio know that my mistake was totally unintentional. My treasurer and I met for lunch, filled out the designation of treasurer, agreed that on her way back to work, which was at the prosecutor's office right there where the Board of Elections was, that she would be filing it on her way back to work. And knowing that and assuming, which is the operative word, that would happen, I opened a campaign account, Beckman for Judge Campaign Committee, checking account with my own funds, loaning my campaign money. I didn't learn until I received certified mail from the commission that designation of treasurer hadn't been filed until about 11 days later. My treasurer indicated it was totally unintentional on her part. She got sidetracked, but this is my mistake. The buck stops with me. And I wanted you to know my error was totally unintentional. I sincerely apologize to the commission and importantly to the citizens of Ohio and especially Claremont County for my mistake. On the positive side of this, what it's taught me is I need to keep my eyes and my hands on absolutely everything that happens in my campaign. going forward, and it taught me a good lesson. So I hope that at the very least, you all know that it wasn't flagrant on my part. I wasn't snubbing my nose at any rules, campaign rules, and I really appreciate the opportunity to be able to come here today and explain my error. I love my position as a judge, and I do. I am a little disappointed that there's a blemish, in my campaign. And I hope I don't disappoint the governor in his selection of appointing me. So anyway, I'll take any questions if anybody has any questions.
Any questions for Judge? Hearing none, do we have a motion?
That we accept the executive director's recommendation.
Second.
We have a motion that's been duly seconded. All in favor, signify by saying aye.
Aye.
Post same sign. Motion carries with a vote of 6-0. Thank you very much.
Very well. Thank you, everyone. Have a great day.
Travel.
Thank you, Judge.
Madam Chair, members of the commission, next I'm going to introduce, I will apologize to the commission in advance. Somehow there was a series of cases that got left off of the agenda. And my recommendation sheet, but I sent you ICWs. So you do have the ICW for this case. This is case number 2023 R-302. Haiti Sadler is the candidate. She received notice, and as I'm looking back at our database, it's there, but somehow it didn't get translated over to the document in which we have the agenda. Anyway, I'm adjusting my recommendation from what's in the ICW to make a recommendation to find a violation, but for good cause, not impose a fine or refer the matter for further prosecution. The explanation is included in the ICW, in which she explained what she did and why she did it. In retrospect, while I originally circulated a $50 fine recommendation, as I look at it a little more, she was within about 10 days to 2 weeks of the filing deadline for filing. And so again, my recommendation is to find a violation, but for good cause, not impose a fine or for prosecution. If Ms. Sandler would like to further address the commission, she can be sworn, and the commission can hear her any additional statements you may have.
Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Thank you, Madam Chair and Commission for listening. Thank you for that recommendation. I am a grassroots citizen candidate, so running for mayor in the city of Findlay was a big step for me. So not being able to find a treasurer, and I went through 6 of my friends, I didn't realize how much paperwork was entailed. So I apologize for being late, which I said in my letter, but, and I take full responsibility. There's a lot of paperwork. I tried to get it all right. I was on the phone with the Ohio Campaign Finance Commission, is it a commissioner group, several times, a dozen times, just trying to make sure that I filed it right. So I just wanted to explain that I did I am a financial administrator. That's what I've done. And I've been an account manager for 20 years. So numbers are an easy thing for me. All those forms were kind of confusing when you're dumping in for the first time. So that is all. Thank you.
Thank you. Any questions? Ms. Sadler? Hearing none, do we have a motion?
So
Second. Okay, we have a motion on the floor. It's been duly seconded. All in favor, signify by saying aye.
aye.
Motion carries with a vote of 6-0. Thank you, ma'am.
Thank you.
Safe travels back.
Yes, ma'am.
All right, the next case will be case number 2023 R-296. This is to consolidate
Yeah, go ahead. No, go ahead.
consolidate with case number 2023 R-256 that was decided on August 10th, 2023, and repeat the imposition of the $250 fine imposed at that meeting. That is,
Lawrence Floyd is here. He is the treasurer of the campaign committee. Madam Chair, members of the commission, just briefly, again, you heard the chair read the recommendation. At the previous meeting, there was a late filing referral. I didn't realize this case was also pending. Responses were submitted in both cases, I believe. Mr. Floyd is here. If the commission would like to hear from him further, he can be sworn to testify. But I believe my recommendation at this point is not to impose an additional fine for this case, but to just more or less consolidate it with the case that was decided on August 10th. If Mr. Floyd would like to be heard, please swear the witness in.
You swear from to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Thank you, everyone. Two separate things. The first one's already been decided. The second one had to do with a withdrawal of $100 out of the campaign account. At the time that happened, I had just opened up a business and personal account at Key Bank. And when I go online, the campaign account is also a part of the online account. And I didn't realize that I was making a withdrawal out of the campaign account. I was thinking I was making a withdrawal out of my business account. I also put money into the campaign account, thinking it was in my business account of $500 or something like that, which we haven't touched. So it was just a mistake. I have since closed those accounts, so I don't make that mistake again. And we will make efforts to take care of the $250 of the bid, but if we didn't, we'll take care of it.
Thank you. Any questions? Comments? Okay. Hearing none, we have a motion.
I'll move the commissioner's recommend, or the executive director's recommendation.
Second.
All right, we have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
The same sign. Motion carries with a vote of 6-0. Thank you very much.
Thank you. Have a good day.
Thank you. Safe travels.
Thank you.
Okay,
Back to the other good cause that wasn't dealt with.
okay. So the last case in the good cause category is case number 2023R-276.
Madam Chair, members of the commission. This is for the late filing of the 2022 Post General Report, due on December 16th, filed in mid-January, essentially. The treasurer states, the post-election report was not required. Attached to a response to a series of emails, and one of the emails from the staff at the boards includes a statement from the board staff that states, I mistakenly told you that you only needed to turn in an amended pre-general report or a post-general report. So she didn't, certainly seeing that statement, I'm taking that into consideration as it relates to this particular case, and recommending that a violation be found because the report was filed late, but for good cause not impose a fine, or refer the matter for the prosecution. I'll be glad to answer any of the questions that the commission may have.
Any questions on this director? Hearing none, do we have a motion?
So moved.
Second.
Okay, we have a motion on the floor that's been duly seconded. All in favor, signify by saying aye. Post same sign. Motion carries with a vote of 6-0. So this is not.
No, we'll do it, but
Oh.
let's get down those
Okay,
names first.
Astor.
That's because that's the one. I did it.
Oh, yes, yes, yes. Okay. Thank you.
Not a problem. I should have written that in.
Okay, thank you. All right. Next category cases is the $50 fine category. These cases are, I'll start with 2023R. So they are -273, -277, -287, -293, and -294.
Madam Chair, members of the commission, these are all situations where the report was filed late. Responses were submitted by a respondent. The reports were, generally speaking, more than 10 days to 2 weeks late. And so almost regardless of the explanation, I felt it appropriate to make a recommendation to find kind of based on the current process before the commission, to find that there is a violation, but and impose a fine of $50. I'll be glad to answer any of the questions that the commission members may have.
Questions? Hearing none, do we have a motion?
Move we accept the recommendation of the executive director.
I'll second.
We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Post same sign. Motion carries with a vote of 6-0. The next category is the $100 fine category. These are all 2023 R cases. So 275, 284, 291, 292, and 295.
Just double checking to see, because sometimes I will make recommendations based on the fact that no response has been submitted, but as I go back and look through these, responses were submitted in all of these matters. However, there was at least one prior violation in all prior cases, and those violations occurred within the last, 5 years or so. And so now that they're back again, after having either gotten a lesser fine amount or generally speaking, and looking back, and most of them were good cause. My recommendation on these kind of cases is to find violation and impose a fine of $100. I'll be glad to answer any questions of the commission.
So moved.
Second.
We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Post same sign. Motion carries with a vote of 6-0. The next case is a $100 fine case, but Mr. Caraway is going to recuse himself.
Make a statement.
Okay, yeah, just simply recusing myself on this matter as I have pending business with Commissioner Corcoran.
Thank you. I mean, you could, but considering I'm just gonna deal with this, okay. It's only one case, so. So yeah, Madam Chair, members of the commission, reports were filed, a response was submitted. This response was submitted late yesterday, so I'm sorry I didn't get it to you earlier. And so there is one or two priors actually. One ahead of myself. I think there's one prior violation.
Just one.
Yeah, just one, that the commission decided in 2021, we imposed a fine of $50 back again. And so my recommendation is to find violation and impose a fine of $100.
And for the record, Madam Chair, they pay their fine.
So any questions? Hearing none, do we have a motion?
Move we follow the recommendation of the executive director.
Second.
We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
The same sign. Motion carries the vote of 5-0.
Please return.
The next case is case number 2023 R-297. The recommendation is to consolidate with case number 2023 R-264, find a violation and impose a fine of $200.
Madam Chair, members of the commission, my recommendation is to find and consolidate it with the prior case and impose a fine of $200. Prior to the pending matter that we're consolidating with, the commission made a finding against this campaign committee and treasurer in April 2022 for a violation of $100 fine. That fine was paid. They're now back again before the commission with these matters. The reports have been filed. The explanation given, they expressed a certain problem in getting backup information that led to a problem with the reports and also not having checks somehow for our campaign committee. But you see my recommendation, I'm sticking with it. I'll be glad to answer any other questions the commission may have.
Hearing no questions, is there a motion?
Second.
We have a motion on the floor. It's been duly seconded. All in favor, signify by saying aye.
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 Pose same sign. Motion carries with the vote of 6-0. The next group of cases is a $25 a day with reconsideration option. These are all 2023 R. 280, 281, 283, and 290.
Madam Chair, members of the commission, these cases are all involved situations where the respondents were referred for failing to file campaign finance reports to check with the Board of Elections. Those reports have not yet been filed. And so therefore, my recommendation, and these are all generally either first time or one other time before the commission, for first time, for the commission to find a violation and impose a fine of $25 per day. But give from the date the report was due, give the respondent the opportunity to have the matter reconsidered if the report is filed, and a response and a request for reconsideration is submitted to the commission. I'll be glad to answer any other questions that the commission may have.
Any questions of Mr. Richter? Hearing none, do we have a motion?
So moved.
Second.
We have a motion on the floor. It's been duly seconded. All in favor, signify by saying aye.
Aye.
Pose same sign. Motion carries with a vote of 6-0. The next cases, group of cases will be to continue cases to September 14th on a request of respondent. Their cases 2023R-298 and 2023R-299. Those cases are continued. The next set of cases will be continued for service. They are all 2023R. 270, 274, 278, 279, 282, 285, and 286. Those are all continued for service.
Thank you very much.
Okay. The next case is a reconsideration. It would involve cases 2022R-423 and 2021R-400. The recommendation is to reconsider case number 2021R-400, vacate the previous finding, consolidate these two cases, find a violation, and impose a fine of $150.
Madam Chair, members of the commission, we received the request to have the reconsideration matter reconsidered, case 2021R-400. We also had a pending case that consolidate these and get them all taken care of. The reports have been filed. The candidate's statement essentially said that they resigned the position, did not realize additional reports were required. Subsequently, all reports have now been filed. The committee is in compliance. And so they're seeking reconsideration on the one. And I just thought it appropriate to consolidate all these matters and to considering we're going through all the effort of reconsidering it and a pending matter, open and outstanding. My recommendation, as it says, is to reconsider the one case, vacate the previous finding there, consolidate these matters, find a violation, and impose a fine of $150. I'll be glad to answer any other questions that the commission may have.
Hearing none, do we have a motion?
So moved.
Second.
Right. A motion on the floor that's been duly seconded. All in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. Motion carried with a vote of 6-0. So the next case is 2022G-2, 021. And Mr. Victor.
Yeah, I kind of gave everybody an explanation in email last night. Mr. Hartman reached out to me a couple of days ago. And as we discussed the matter, it was his belief that deciding this case potentially on briefing was appropriate. In my conversation with him, I encouraged him to be in touch with counsel for the Ohio Democratic Party, which he did. As the day went on yesterday, those two went back and forth suggesting various timeframes for filing materials with us and coming back on this date. And so based on their input, what I instructed them was that the complainant, Mr. Hartman's brief would be due by, I think, September 12th. Mr. Hube, who's representing the Ohio Democratic Party, his response to that would be due by, I think, September 26th. And then should Mr. Hartman desire to submit a reply to that submission that would be due by October 4th, so that all materials would be submitted to us about a week in advance of the meeting. I will then circulate them to you, and then we'll bring this matter up on October 12th for the commission to determine how it wants to proceed. Essentially, all the evidence will have been presented, all the legal arguments will have been presented. This is a bit different than we've done before. We certainly have made agreements on or accepted agreements with the parties on how to act. We've done a variety of things. But honestly, we've never gone, the commission's never before gone and just taken a matter under consideration on briefing and then made the decision based on a brief. So this will be a little bit different. I certainly will review those materials as well in advance. As you have any questions, I would encourage all of you to be in touch with me as it relates to that and how we'll proceed on the 12th. As I get new materials in, by the way, what I anticipate doing is not waiting until the end, but when I get Mr. Hartman's brief in, I will circulate it to all of you so that you'll have it around September 12th or 13th. Mr. Hubey's brief, and then, toward the end of September, I'll give it to you at that point. So that you'll have it in time, in sufficient time in advance in order to kind of digest what it has to say. And again, if you have any other questions, I will have gone through those materials as well. As I always say, I don't necessarily make recommendations on hearings, because at a hearing, my expectation, I think the expectation is that each one of you will assess the evidence presented to you as you believe appropriate and make a decision, violation, no violation, whatever the case may be, based on the materials that you get. So I don't anticipate making a specific recommendation, but I'll be glad to answer any other questions that you may have. It's probably the best thing I can say. And so I think, and so at this point, my recommendation, as it says there, is simply, you don't need to worry about the briefing schedule, but just continue this case to October 12th for further consideration. That's the date that I agree with the parties. Mr. Lyle has a question, so I presume you go ahead and take that question, Madam Chair.
I'm just curious, their rationale. Why did they opt to do briefs and not the hearing?
They, as I talked at least initially to Mr. Hartman, and also the other thing, you'll be getting another response that was submitted Monday, I think it was, by Mr. Hubey on behalf of the Ohio Democratic Party. I will also circulate that to you. After Mr. Hartman digested that submission, and the reason why you don't have it is because we came to this agreement. So I just never sent it out to anybody. I haven't even read it, to be honest with you.
So Hartman has it.
Hartman has it.
That's
yes. But after having received that, it was his kind of assessment of the case, in terms of based on what the Democratic Party is saying in their response, that it was appropriate to just go ahead and make legal arguments, identify certain elements of the facts, and then present it to the commission. And so that was his suggestion. I didn't disagree with it. And then, again, after he reached out to Mr. Hubey was on board as well to do that. Also, they get saved a trip down to Columbus, at least as it related to today. I've got something else on the October 12th meeting, so Mr. Hartman will be here that day, and I'll have to work through with him and Mr. Hubey whether Mr. Hubey attends or, whether we just go based on the briefing without having any further comments from council at that time, since it's potential that Mr. Hubey may not be present on the 12th. Anyway, that's kind of where it stands at this point.
Was this the case that in the email you had talked about the respondent not being in Ohio? Is this?
That is the Rakowski person there is, my understanding is she's a former employee of the Ohio Democratic Party who worked for the Hamilton County Democratic Party. The essence of the case is there were contributions received by the Democratic Party to the tune of, I think, over $400,000 that were identified as being the responsibility of Ms. Rakowski,
Okay.
who was,
As a contributor?
that's what the reports reflected.
Oh,
Yes.
okay.
Mr. Hubei has an explanation of that set of circumstances and what they've done, I guess you'd say, to correct the situation in the interim. And so I don't think anybody is, certainly she's still part of the case. And I reached out to her by email yesterday to just kind of give her an update on what, you know, the fact that there was going to be continued, go back again to October 12th. But she left her position with essentially the ODP, moved to Chicago. I'm not sure exactly what she's doing up there. She did submit a response. This was a preliminary review. And so we had that before us. She did not respond. She has, at least as of this point, she has not responded back to my email yesterday. And so, yeah, I mean, the whole situation is kind of I mean, at one level, I guess you would say, how is it that the ODP did not recognize that someone who was making, you know, I guess an okay wage for the ODP, but not enough to justify over $400,000 in contributions, get credited with $400,000 in contributions.
And this is, she worked for the county party.
She was my understanding is,
Interim director.
yeah, she was the interim director of the Hamilton County Democratic Party, who was an employee of the Ohio Democratic Party. Right.
Both
Yeah.
parties.
Her position's different.
You know.
Yeah, she-
Yeah, yeah.
Right, we do have a statement.
Yeah,
from
okay.
her. And I'll make sure all that stuff gets circulated to you again in advance, so that you have all of the materials from this case.
So
As I get
rather
it.
than a physical hearing,
Right,
we'll make our decision based upon written.
that is the expectation that Mr. Hartman, Mr. Hubei, and I have all agreed to.
Has
Yes,
that happened often during your tenure?
this is never happened before. This will be a first,
It's the equivalent of summary judgment, right?
more or less, yeah,
Yeah, a bench decision.
more or less, yeah. You know, I mean, that's,
Whether
and I can't remember whether I indicated that to Mr. Hubei, but I certainly indicated that to Mr. Hartman because I had talked on the phone with Mr. Hartman Tuesday afternoon after I got back into the office. And that's when I, you know, kind of walked through the process with him. And I said, this would be a first, because we have certainly done a variety of things over the years in terms of resolving matters, but we have never before done it just based on written submissions. We've had written submissions before. We've also had either argument or certain testimony provided. You know, we might have testimony provided at hearing, and then subsequently the parties kind of gave summary arguments in writing. You know, that was all kind of included in the makeup and in the documentation of the case. So this will be a little bit different.
They are horizons being extended.
Exactly.
And did you say Mr. Hartman will be here on a related matter?
If you guys recall, when a couple weeks ago, we had the case where we decided that there was a potential frivolous matter before us. I had already decided to set that matter on October 12th. So, you know, Chris and I were working on that. I set it on October 12th. And then as these two are going back and forth and coming up with a schedule for this, I said, here's the meeting dates on which it potentially could be held. I gave them the October, November, and December date, you know, the remaining dates this year for the commission. So I laid it out to them in advance. And they came back with October 12th. And so as I was finalizing that with everybody, I said, by the way, Mr. Hartman, you don't have notice yet because we just got notice in the mail yesterday on that case. And so I was like, here's what I set the other case up. So you're potentially gonna be here anyway when we make that decision. So that's why Mr. Hartman would be here, arguing that matter is frivolous.
But he would not be asked to respond. to
Not
this?
necessarily, no. Like I said, I'll have to work that out with, you know, either say, you know, Mr. Hubei comes down, you know, maybe he's got another, you know, maybe he just decides to come down and be present because he wants to hear. I have not had that conversation with him, but he is aware that Mr. Hartman has another matter because the email that I sent to everybody confirming the schedule I sent to both of them. And I included it in that email. By the way, Mr. Hartman, this other matter is being set on that date. So Mr. Hoover is aware of that.
I'd suggest that allowing one of them to respond when the other isn't here wouldn't be appropriate.
I would tend to agree with that wholeheartedly. Yep. And so it becomes a matter then of, you know, does Mr. Hoover come down or does he just, you know?
Yeah, they ought to have an agreement if they're.
We've got time and we've got.
Right,
time.
you have plenty of time.
I would go one step further, especially given the confusion of Mr. Hicks and the continuance today, that we are absolutely 100% crystal clear on
Yeah.
what's going on, because even if Mr. Hube shows up just because he wants to hear the discussion commission and hear the result, that's different than being prepared to argue the
Right.
case. If Hartman shows up, so Mr. Hartman shows up prepared to argue, it would be unfair. And then we're doing continuances and whatnot. Everybody should be 100% on the same page, like we're not today.
Agreed. And as I look back, and I think I said this to you, but as I look back at the email, Mr. Bry presented me with the motions to continue. And I almost every other thing between he and Mr. Hicks throughout, you know, both the prior previous case and this one they both included the other on there. And so my assumption was that, you know, that I didn't look back at the email that Mr. Bry sent to me in April that included these motions. And he didn't include Mr. Hicks on there. He just sent them to me, or his assistant sent them to me, whichever the case may be. So
To be fair, as an operational matter, the commission should ensure that
I don't disagree.
everyone coming up is on the same page, understands what they are appearing for.
Yeah.
And to have the appropriate time to prepare. And not. We should have made sure that was the case.
I don't disagree with you. I'm not trying to pass off, you know,
Fair enough.
responsibility. I don't disagree with that. I'm just saying that is what I
That's what
did.
happened. Yeah, Great.
Now, I mean, you know, and as I went back through the emails, we originally talked about scheduling this in May. And I think it was, and May wasn't going to work for some reason. So then I suggested moving it to June. That didn't work for Mr. Hicks, these preliminary reviews. Hicks suggested July. That didn't work for Mr. Bry. And so that's why we end up here today, is because, you know, we went back with emails as it related to scheduling these preliminary reviews. And I made an incorrect assumption that Mr. Hicks had the motions. Because Mr. Bry is normally pretty good about doing that. And you're right, that is, it's more than a mistake on my part. It's an oversight that shouldn't have happened.
And I don't know what the current practice is, but it might make sense. A week in advance or whatever it is, perhaps when you send out preliminary agendas, that there's also an email to all parties that provides, you know, something, so there's certainty. That's a matter of, you know, of operation procedure.
Yeah.
And Mr. Richter, I don't want to wade into obviously that particular case, but you and I had a brief phone discussion a few weeks ago regarding an online case filing system, which, by the way, just so the commissioners are aware, we do not have one. As you're probably aware, I thought we did. So I thought these beautiful ICWs were computer generated, and apparently the staff painstakingly fills out every one of them. Would that be, if we had an online system, would automatic notifications take care of notifying all the parties involved in a matter?
I guess the simple answer is it could, but I don't know enough about all of the various potential electronic systems that are out there. Yeah, I mean, Chris and I discuss future commission meeting dates and notices going out, what notices need to go out, and we extract information from the database and put it into the notices or the ICWs. And that's how we provide permission to either you guys or to the parties.
What's, well, the ICWs are well done. I thought a computer was doing them. And in fairness, it's the staff, but I, talked to Mr. Richter, and it was something that I certainly wanted to bring up at some point was, asking the staff to at least investigate, what, I know the Board of Tax Appeals, has an online system, this isn't court, but other commissions do and courts do. I would really like for us to take a look at it. It may be something that is not possible with our budget. But
Can I just ask real quick before we wade into too much more? Do we need to make a decision on the case?
Yes.
Can we please go ahead and finish that and then we
I
can?
thought, I
No,
think
no,
we're done.
and I'm sorry. So
Okay.
can we just go ahead and, the recommendation is to continue the case to October 12, 2023, upon the request of the parties for final resolution.
So
Can't the chair do that? Does this continue on?
I don't know.
Oftentimes she does, but for a hearing like this, I would prefer it to be.
I just been for one clarification.
So, Madam Chair, I'm sorry.
No, we all,
Yeah.
but it's a good discussion.
Sure.
But I'd like to finish this and then, we maybe pursue. Agree, yeah.
Second.
Okay. We have a motion on the floor that's been duly seconded. All in favor, signify by saying aye. Aye, opposed, same sign. Motion carries the vote of 6-0. Thank you. And then continue.
Yeah, no, that's all I wanted to bring up in reference, as the newbie here. Certainly, I think our staff does a great job. But I also feel like, to a degree, there's a ton of manual work in inputting all of this data, and then I'm trying to say this in a really nice way. It seems very antiquated in some regards to the way we're doing this. That is not a negative comment, Mr. Richter, Mr. Hughes, at all. But I would like the staff to at least take a look and see if that's something that they could use and would be helpful to commission operations and being forwarded.
Madam Chair, to Commissioner Fairways, but we have had previous conversations about similar efficiencies that could be created and alleviate some of the burden upon both staff members. I don't know that they've been able to do that because of the significance of the burden, or to what extent they've done that research. We talked about accepting electronic payments, et cetera. So these things could be quickly closed, even right on the spot, potentially. I was thinking for the comments that were made earlier by one of the attorneys that were relatively derogatory towards the commission. And I sent an email in accordance with such information that perhaps making all of the materials available even on site the day of a hearing is something that happened regularly in the House of Representatives. If things are submitted 24 hours in advance, those things would be copied. And as much as it pains me as a 34-year-old professional to say copied, printed, and put on a table, that would alleviate that burden on us to show any preference or deference to any parties in the room, but give everyone equal access to those materials. But there also might be, to your point, an online repository that could be created where those things are made available, where you can say, hey, online right now, you can access it on your phone, your email, wherever. Or another option, since you're already emailing it to all of us, is if you have that grouped in an email without our names associated with it, it could be something forwarded to Chris, that if one of them approaches him, he can say, great, what's your email? I'm going to shoot it all to you right now. So just a few different things that were going on in my head and all of this conversation, if that's helpful or not.
Well,
Muddy the waters.
I agree with you. And in my conversation with Mr. Richter, I asked, whenever we have a case or a respondent that has a prior violation, I asked, well, how do we know that they've had prior violation? And my understanding is that you have a Microsoft Access database. And so, and maybe that works okay. But an online system would notify as soon as I understand it, as soon as a filing is made in 2022 G021, all the parties get a notification that says, hey, there's been a filing, a document uploaded, whatever. Again, I don't think there's, if there's past work that's been done, I certainly didn't mean to insinuate, step on anyone's toes, but, I
The
think it's
point is
something,
you're not insulting us.
that's fair. Then why aren't we doing, no, so I would like to ask the commission staff to look into that. If they need any help from us, certainly let us know. I think a great first step is contacting the Board of Tax Appeals, and some of these other agencies within Ohio government. DAS may already have a preferred vendor.
Yes, Salesforce, don't go there.
Okay, all right.
Use Salesforce too.
Do you-
And
I've heard of it.
they will, and we're not the only organization that does that. Salesforce is great at selling their product and then, take our, hammer and will force, and then it never is good. That's really expensive.
Yeah.
That's what DES will put into work.
Okay. And I remember
That's really expensive and really painful,
when,
And they're growing too fast and they can't support what they're doing.
but they charge you for all the consultative services to have it not
of
work.
course, they-
Yes.
And they spend a whole bunch of time telling you how great it is. It's anyway.
I think this would be a great project for a statewide office holder, like a treasurer's office that has certain pockets of money to increase efficiencies within governmental entities. For small guys like us, if we could pull our voices together and say, hey, what about those of us who are left behind financially? Just a thought.
Which about, what was it, a year ago to a year and a half ago or so, we did venture down this road where someone had said, this agency has got this implemented, you ought to look into it. And so we did, and had multiple meetings with a company that said, yeah, this would work perfect for you. Here's, how this works. Here's what you do. And, we set up meeting after meeting after meeting with them, and then they dropped us like a bad habit, disappeared. Haven't heard from them since. We haven't.
Are they still in business?
No clue.
Okay.
Once it did the Franklin County Court of
Okay. You
Appeals.
must have.
I was gonna say that I think a good parallel would be different court systems because it's the same process.
Right, that's who I reached out to initially. They gave me this contact, this company. It's out in Utah, as I recall. And I think it has great potential. And we went back and forth with them for a little bit, and then, I mean, you're certainly welcome to say we dropped the ball to a certain degree, but they never
Reached out.
how are going to sending us their basic brochure that says, hey, here's what we do.
Well, I'm sure what they heard was 2 seats and it wasn't worth the time and effort.
And that could very well possibly be it.
What would be ideal would be to find a court system that has something implemented. To Commissioner Hagan's point, you partner with their license as a couple of extra seats and then, some customization that would provide more incentive for the vendor because it's an add-on to what they already have. They want to make that client happy. And also probably reduce cost as opposed to a new instance, right?
Yeah.
But now you gotta agree with whoever the let your partner, which is a different conversation. Should be simple, but it
Should.
never is.
And
Well, we also reached out to, at the same time, we reached out to technology staff, let's say at DAS,
I'm sorry.
kind of saying, hey, is this something you could do? And that just kind of fell by the wayside.
They probably told you
emails.
They probably said, hey, ask Chris Hughes, he's your contact person, because that's what they did to me the other day.
Yeah.
Then, like, they told me to call, Mr. Richter told me to get a hold of DAS, so I get a hold of DAS, they said, oh, get a hold of Chris Hughes, and Chris Hughes is just saying, that's not. What,
Right.
yeah, he's the HR guy, well, but apparently he's a technology guy too, so.
They had my paycheck wrong for taxes and I eventually, same circle.
Changed your
I eventually, and I'm having this on tape, I eventually had to send an email to the deputy director of DAS in charge of HR just to get someone to stop, tell me either they couldn't do it or Chris can do it, or, after 3 weeks I just emailed the top guy there. I got a call in like 2 hours from their assistant complaining about us, but I let them vent because they said they would fix it. I mean, I was like, I'll take yes for an answer in my meeting as well.
I think, you know, I used to be a commissioner in a very small county and
Right. Yeah.
there were court system vendors that specialized
Especially in
in
this, yeah.
small potatoes, so to speak. So,
Northwoods was one that used to specialize in smaller agencies. I don't know where they hit.
Henshin, I think, Henshin. But so, Mr. Richter, I don't know what you want to do with our conversation, but I would,
Well, if I may, I think there's a segment here as we're ideating internal
Yeah,
strategies.
I was waiting to go there.
Okay.
That's okay.
Uh,
You don't want me to take over.
no, you can take it, but I'll just say that.
Bill, he's having so much fun with it. I think he needs to.
I hope you guys picked that up.
I did.
Hillary and myself, we met just Tuesday to talk about the overall evaluation, right, of the executive director. So with that, I think that's a segue. And
Sure, it's a perfect segue. So, Commissioner Lyle and Executive Director Richter and I met, Tuesday with a focus on getting something in place for this year, right? So that there's at least an order, hopefully, of, evaluation criteria that we're all in agreement with. We would have presented our thoughts today, but with Commissioner Tavares out, we wanted to have the full commission. So hopefully we're able to do so at the next meeting. Taking a quick step back, a lot of the things that were on there originally, we decided to table to the 2024 evaluation, right? Some of the strategic stuff and what, you know, I got a little of jostling from, I guess is the right word. I use the term creating internally ideated, strategic projects. So this would fall into that. That's one of the things we wanted to put in sort of to recommend and discuss for the 2024 evaluation and call it strategic plan. So, and we can discuss later, we thought we would, continue a potential subgroup that would work on the 2024 after the 2023 is done. I would encourage all the commissioners and staff to, kind of ask for ideas. This is a great one. I know we've talked about credit cards. I know I've talked a lot about metrics. We'll have to recognize that there's only so much bandwidth that staff can have. But as we think about 2024, maybe it's conversations with staff and commissioners, whatever it is. But, start to come up with a list. We're not going to be able to do all of them. We'll have to have discussions around what makes sense. But hopefully, by end of the year, we'll have a pretty broad discussion on what I would call, 2024 strategic priorities for the staff to look into and focus on. And I think it's kind of this fits perfectly into that. But there are other ideas and thoughts that we all have discussed and may still have to present.
But yeah, Mr. Hicks brought up a good point too. That
Originally, okay. Anyway.
that, it had been discussed because with COVID, obviously we all were able to do things, remotely. We've discussed, making the option, putting the option out there for people, to be able to appear. And we've discussed different options of things that you utilized for your business and things we use at our office that would allow that to happen if we were able to extend that. So that's another one of those ideas that's kind of languished out there. But I think it's not terrible to not expect someone to drive from Cincinnati or Cleveland or wherever. If they, if they do want to say something and they want to explain themselves, which, we've heard today, that's important to people to let us know what happened and why. I think that's another issue that's been brought forward, several times in the last couple of years. And so.
And it does have an impact on least in my mind, if someone took the time to come here and explain, just like the judge or whomever, it makes a difference to me that they took the time not only to respond, but to be here. And, you know, the one gentlelady was from Finley, you know, was,
Yeah.
it,
wins.
your part of Ohio, it's sometimes it's what, 2.5, 3 hours, like Trumbull County. I mean, we had someone in here from Trumbull County. It's a long,
Yeah.
it's a long way. And I agree with you, Chair. I know you talked about it. And so does the commission staff, do you have any idea? Maybe we could put that in the goals for 2024. Is that like, what kind of technology do we need? A television, a couple of monitors? I know I'm simplifying a very complicated matter.
Well, Chris and I've tried to not complicate, to simplify it in an effort to get it done. And so we've had conversations about it before. And,
Separate me too.
I'm lonely over here, by the way.
Nobody, you can be
She'll be back.
Oh, sorry.
You're causing trouble.
so,
Maybe-
yeah, I think that's something that I would, been thinking about, trying to implement something like that, maybe in the new year.
Yeah.
And,
We had discussions on the degree of the case as well, you know, is it
Right.
the severity of what is in front of us?
right, if we're, I mean, similar today, in Mr. Hicks' defense, if we're just arguing a motion, something along those lines, that would fit, but we've talked about, if you're gonna have a full hearing and you're gonna have witnesses, et cetera, that needs to be physically present. I think that's an appropriate approach toward, combining the technology aspect of, remote activity as opposed to in-person activity. So,
We don't have any restraints for making that even more available to the public electronically where we are restrained as commission members by the revised code.
right, you have to be physically present now.
And it's so they're getting ready to drop a bill or have, allowing a lot of entities throughout Ohio to meet virtually.
Why are you smiling so much?
I'm pleased to report to you that the Ohio Election Commission is on the forbidden list.
On the forbidden.
Yeah, like they specifically, I'll send a screenshot of it to.
Did we abuse this
Why?
information? We were very present.
No.
I didn't even use the restroom. I was very pregnant. That's why I didn't even leave my screen.
See, it's, the General Assembly or any of its committees or subcommittees, any court, the State Board of Education, Bureau of Workers' Compensation, the Ohio Elections Commission,
Wow. we got-
a Board of County Commissioners, a Board of Trustees, or a legislative authority of a municipal corporation. Those are the excluded.
Let's look on the camera and say, when we were doing remote, I think not all of us, but most of us were here, we had quadruple public participation. It was a great thing. And we had really minimal technology hiccups. We had some, but they were, minimal. And, that is very disappointing to hear.
Well, I
Because
just,
this is the type of thing that should be investigated more before such decisions. It was at least 4 times participation. We would have 40, 50 people on the line, because they could participate, and it was wonderful.
But that could still be achieved right now. We just have to keep our butts in chairs. That's the difference.
I thought it was interesting, because there are so many boards and commissions throughout state government
That were permitted.
that, well, those are the only ones that are excluded. Pretty much everyone else, under the proposed legislation can't. So I just thought it was very interesting that, the state medical board, state pharmacy board, the cosmetology board, all of those, the state liquor commission, in theory could, and we're on the list. Mr. Richter, you got us on the list. How'd you get us on the list?
So it sounds like.
No, it wasn't.
I know.
They
I
do
know.
list
There's
similar
all
to
the
what law.
various things that the previous commission
Which
did.
I
I guess.
think it's totally good.
Take it as a compliment. It's
Okay.
the authority.
I have 2 things which I'll go relatively brief.
I'm sorry to be rude. My dad's in the hospital and they called, but it's all good. So I apologize for looking at my phone. I apologize. It's all good.
I know you've been playing the gas.
I knew. Knew something.
If there's not a shut up signal, but more than that, I don't know what.
No, it's not. I promise.
I-
I mean, it's just my dad makes me nervous because he's like a fall risk. So he gets out of bed and just starts trotting around, but it was all good. So I apologize, but thank you for putting up with me.
She's ready to whack me.
And if I was to pick up a car full of kids, so
Okay.
you'd be doing Ohio service.
Mr. Richter, I'm gonna turn the floor to you.
I have two quick things. One is, we kind of talked about it. I talked to the, actually three. I talked to the folks at the treasurer's office about, getting, electronic payments, let's put it that way. I went back and forth with them. And so, beginning in September, they are going to start working with me, to implement an electronic payments system it's probably starting as of January 1, starting in the new year. Now, that won't, at this point, it's not necessarily going to include credit card payments. Because as we were going back and forth on that conversation, they didn't feel that, well, we were all concerned about the cost impact of that and how to deal with it. And they thought that just implementing an electronic payment system initially would be more beneficial. I discussed that briefly with Mr. Lyle and Mr. Knight on Tuesday when we met. I think I'm probably fair in saying you're a little skeptical of just doing the electronics payments and not necessarily credit cards, but it'll start us down that path. And they certainly didn't say we couldn't add to it after we do the initial one. So
So the
For them to cover their fee.
electronic funds.
That's right.
Yeah, cover the fee.
And it's, and what the,
Yeah, we're not charged.
I looked at something that they sent me and it would be on our website, we have a portal that says, I want to make a payment to the commission. And they put like their name, case number, and et cetera. And then they get directed essentially to the banks or to a secure website that, you know, essentially has the bank take the money out of their account, put it into our account. And then we would need to go in like the next morning, and, you know, we would be given the ability to go back and look at the transactions that are reflected to the commission and say, okay, yeah, we, you know, those are the ones that we got, those were approved.
So you're not doing a cash sweep. It is directly to our account.
It's, well, my understanding is it goes into our account, but we have to confirm it in order for it to be accepted. Yes,
Well,
that's the nature of the conversation.
I concur, Mr. Richter, to look at. I have some tenants, for example, they are, you know, they're Gen Xers, millennials. They want to pay me with cash. They do not have a check. I'm like, can you please go get a check? You know, I don't want their rent money in my mailbox.
Yeah.
And I do think that, EFT is great. It is a great first step.
Right.
But I think a credit card component's important.
Yeah.
It amazes me how many people don't.
Right.
Like.
It's a convenience.
Original, I'm in a good point when we have the discussion with sunshine laws, record, open records, giving your bank information to, and I know it's to a different site, but you get into it, you know, it started as on a state government website.
Right.
You know, I don't want to be risking that somebody can do an open records request to get my bank
They
info.
should be, that's redactable. But
I know, I've done
I've
this
seen all
many
sorts
record
of
requests,
elections.
and they send the stuff and things are half redacted
I
and
know.
other half, it's not, because who does the redaction?
Right.
Right, they aren't very conscientious.
well, sometimes at boards of elections, you know, I've gotten a report and they've got, you know, the checks from donors. And they just made a copy of them and made them a part of their report. And I'm like, oh my God.
Yeah.
Routing numbers on there,
Well, that's, I mean,
account
that's,
number, I mean.
we obviously get checks as well, and we're regularly putting them in the account, and I'll give Chris a lot of credit in terms of, you know, we obviously have to give that information to the bank as we're depositing, but then we redact that information before it goes really any farther so that we're not circulating that kind of stuff. The second thing is I talked to our budget analyst as it relates to some of the things that we've discussed here in terms of, my retirement, splitting the positions, having just one position, all those various things. And I guess the bottom line that I would want to bring up to your guys' attention is his suggestion was certainly, broaching the subject with the governor's office and OBM at an appropriate time frame, because next year at this point right now is when I've already got budget information and I'm supposed to be putting the budget in for the next biennium. Because I'm guessing I'll have to submit it in October. And so his recommendation was opening the conversation with the governor's office and OBM next May or June, in that time frame. So it's gonna come around quicker than we might want to anticipate. But that's fine. I don't have any problem doing that. Just wanted to let you know that.
Did the analyst have any reservations about?
No, he said it made sense to look to do it. He certainly wasn't going to say, yeah, it would, you'll get whatever you want. But, his suggestion, I think, made sense. And he didn't discourage me from opening up the subject and presenting it to, let's say, the powers that be, even over the powers in the General Assembly, as it relates to kind of walking it through the budget process. So there's that. And then the last thing is, I got one more thing, because I talked with Mr. Kolke this morning, and I talked to Mr. Knight and Mr. Lyle Tuesday, and they both indicated that they didn't get any kind of additional new educational requirement that we have coming up, but Mr. Kolke did. He got an email. I got an email last Friday, and Mr. Kolke said he got one. Did you get one? We talked about that briefly.
I did not. I think I did.
Okay, but there was an email being circulated by the learning area at DAS or whatever, where by October 27th, you're supposed to go through this, and it takes about an hour.
October 27th?
October 27th. There's about an hour's worth of 4 different portals that you go through, and it's all on essentially computer technology security. It starts off with a former hacker who,
Oh, gosh, that's awful.
a former hacker who has his own business now, that helps people keep from getting hacked, et cetera. And so when I get back to the office this afternoon, I will forward the email that I got, and it is from a trusted source because you're getting it from me.
Can I check there and you did it for
Don't
work?
worry about it.
Yeah, don't work so.
We're not on state devices.
Yes,
We're not in the network.
we don't have.
I know
state email.
I'm not trying to be argumentative.
And I've had various
It doesn't
people say,
affect
oh,
us.
right, you should have state emails and all this kind of stuff. And I might thinking too is, that would just be one more thing that you guys would have to deal
Well,
with.
look,
Yeah.
Plus all the rest of
with
those.
all due respect to this commission, I have a small business that has to pay sales tax. So when I had to get a My Ohio ID,
Oh, it was.
when I try to log in now to pay my sales taxes, my portal's gone. Like I have no ability to pay. And so I've been on hold a lot with the Department of Taxation, and they can't understand what my problem is. And I'm like, I'm a quasi employee because they did away with the gateway. I don't know if you knew that or not, or their old system. So now everybody has to have one of those My Ohio IDs, even the general public, Bob Buckeye that owns a
Random
business.
12-digit number.
Right, so they have taken My Ohio ID, my old identity as a
Yeah.
taxpayer, whatever, and it's gone. I have no ability to pay them. And of course, I'm trying to call taxation. They don't understand.
So you're saying less is more? Is that what I'm hearing?
Totally.
I
have
second
the
that.
same issue. I don't have
Second.
sales
Yeah.
tax, but for BWC. you
Yeah.
go in, And I spent, I don't know how
Well,
many.
who did you call? Maybe I'll call.
Oh, I mean,
If it
I
worked.
don't remember.
Okay.
I ran through like 5 or 6 people
Anyway,
where somebody understood it.
So you're gonna forward
I'm
that?
going to forward to
They
you
try to
all
find
the email that I got
They will.
that lays out, that has
I'm not
the
gonna
information in it that you go through. and it says you gotta have it done by October 27th, and you can get follow-up from me, just because they probably inappropriately sent me the list of 50,000 people and what their status is, that I've had conversation about as a part of that training that says you shouldn't do that, but they did it.
Oh, good.
Madam Chair, I move a motion to adjourn.
Amen. I mean,
Oh.
oh, wait, is that? wrong?
I don't think that's what
So
Robert's
all-
rules of
we
order.
have, seconded, all in favor, signify by saying aye. Post same sign, motion carries with vote 6-0, motion, or meeting adjourned.
Thanks for your patience and thanks for.
Good memories.
So Stephen, I basically have two. Oh.
We're back.
So that was the solution. You know, I'm trying to pay these people the sales tax that I've been held and now I'm trying.
I did, yeah.
And
No, but
you should.
it'll be fine.
Was he
I mean-
by himself? Was he-
Well, he lived with a friend for 13 years, and basically when we pick him